Welcome everybody to the Young AFSA Mediation Series. This is a three-part online workshop designed to equip young lawyers and young practitioners with essential skills in mediation. My name is Vincent Manko. I'm a director in the Dispute Resolution Department at CDH. I'm also a young member of the Young AFSA Steering Committee and a member of the Training Subcommittee. I'm joined by Stephen. Stephen is a director at Tala Africa. He specializes in construction law. Thanks, Stephen.
Thank you very much, Vincent. We are very proud to be introducing this third series or third webinar in the series of three. And as a brief recap of what the previous two webinars covered, if you were able to attend those, you'll remember that Advocate Duncan Turner hosted or was part of the first one. And in that webinar, he gave a very brief overview of what mediation is and how it lives in the broader dispute resolution mechanism context. And then we moved on to the second session, and in very briefly there as well, Advocate Chris Loxton, he dealt with how mediation fits into the spectrum of dispute resolution, specifically in the mining and construction spheres. Advocate Loxton gave us a lot more detail in respect of how mediation works, with particular emphasis on how mediation would work very well in the mining sphere when it comes to government participation. And in that case, unfortunately, he came to the conclusion that it's unlikely to happen. That does not, however, mean that mediation cannot work elsewhere. So I'm going to hand back over to Vincent to introduce the first of our speakers.
Thanks, Stephen. Our first speaker today is Belinda Scriba. Belinda is a director in our Dispute Resolution Department and has been a director since 2017. Her experience includes litigation, arbitration, both international and local, in the areas of insolvency, business rescue, corporate and commercial contractual disputes, Companies Act disputes, and international trade. Belinda's work has taken her overseas, where in England she worked as a corporate private measures and acquisitions professional support paralegal at Freshfields. That was before she commenced her career in South Africa. Since then, she has, amongst others, advised international and local entities on the aspects of South African maritime and admiralty law, both litigious, corporate contracts drafting, has represented entities in seeking recognition of foreign judgments and bankruptcy proceedings. Belinda has also advised clients in respect of liquidation applications and applications relating to the CAPA, NCA, PAJA, and the Companies Act. Belinda was listed in the Legal 500 Private Practice Arbitration Power List Africa in 2023. Moreover, she's a trained and qualified mediator. She's also extensively involved in the non-profit organization called Mediation in Motion and has been involved in numerous successful mediations. Thanks, Stephen.
Our second speaker is Patrick Deale, with more than 25 years experience as a labor attorney in a wide range of industries and sectors across South Africa. Patrick has conducted and represented both employees and employers in the Labour Court, the CCMA, various bargaining councils, disciplinary inquiries, and arbitrations in excess of 400 cases. Patrick has been appointed as an acting judge in the Labour Court of South Africa and has also acted as a commercial mediator and labour arbitrator for many years. In the year 2000, he co-founded Tokiso Dispute Settlement, where he was full-time CEO for 6 years. He's also accredited by the UK-based Centre for Effective Dispute Resolution as a commercial mediator, coach, and assessor. He is the co-author of the Labour Relations Handbook, published by Juta, and has been a regular host of the Labour Line on Talk Radio 702. Patrick established and currently heads up Deale Attorneys, a firm which focuses on the opportunity to improve and build South African business relationships in partnership with business clients. The firm specializes in labor law and commercial mediation services, with a particular emphasis on resolving conflict at senior management levels and disputes between management and unions. So how we plan for this webinar to work in a bit more detail is when it comes to questions and answers, We have split the webinar into two distinct parts. One where Belinda will address us on her experience and her knowledge, and Patrick will then take over the second part. In between both of these parts, there will be a very short Q&A session. So I invite all of our attendees to make use of the Zoom Q&A function. You'll see it in a little box with the question mark at the bottom of your screen. Please do type your questions in there. We're going to be keeping an eye out for them, and we'll then put them to our panelists, and they will then be able to respond directly to you. Please remember, you are entitled to put your name there if you'd like the question to be assigned, to be ascribed to you, or you can use the anonymous question asking function as well. So at this point, I'm going to hand over to Belinda. Please take it away.
Thank you both for a lovely introduction. It always sounds better on paper than it actually is sometimes from a practical perspective. But yes, Patrick and I today are going to be giving you hopefully a passionate appeal to consider mediation in your bright futures going forward for a bunch of various reasons. And hopefully our message will come across and you will see the value of mediation in our discussion today. So I'm sure between the previous two panelists, you've had a lot of information, and I'll probably reiterate a lot of it, but it is important. So mediation has been around for an extensive period of time, almost probably, or even before arbitration started gaining traction. And it hasn't really gained traction until recent years, and there's a lot of different reasons around that. And I'm going to go into the purpose of mediation and why it's becoming more and more important. So I think let me just touch on the importance and why it's becoming important. I think in South Africa, we're all aware that our courts are inundated with matters, and our court rolls are extending into absolutely ridiculous timelines, and through no fault necessarily of the court, but just because there is so much litigation out there, and also because litigants have learned to be very obstructive with the court process. And that's where, firstly, mediation, I think, is going to start playing a big role, because we do need to cut down what's on our court roll, and there are a lot of matters that are capable of being resolved without going through the formal litigation process. And those matters, I think, are ripe for mediation, and that's where mediation is going to start gaining more traction. This is obviously, it's been seen by our judiciary and our legislature in that they've actually put in our court rules now, both magistrate and high court, that mediation needs to be a consideration. And I know for a fact that there are a lot of courts, especially magistrates, that are actually coming down quite hard on practitioners for not advising clients about the mediation process. So that's one of the purposes now of mediation, is to try and take some of the load off the courts. The way it takes the load off the courts, obviously, is the first one is that you actually find a resolution to the matter and you don't have to go through litigation in order to resolve the matter. The other way is to actually start zoning in on what the actual issues in dispute are. So as litigators, Vincent and myself and Stephen and Patrick have all experienced litigation. As litigators, our first port of call, I think, is automatically to say to our client, throw everything but the kitchen sink at this matter, and something will stick, if not all of it will stick. And what that means is that when you get to court, you're trying to prove a myriad of different claims, which may require different experts, different witnesses, a whole stack of documentation that witnesses need to speak into. Whereas if you pare down what the actual issues in dispute are, and if you're unable to resolve those in mediation, but you've managed to pare it down, what you've done is you've actually shortened the time period of the court's time, as well as each litigator's time in the courts. So that automatically starts bringing down the amount of court time that you're taking up in order to resolve your dispute. So that is one of the other purposes of mediation. The other one is to try and find solutions that are outside of the box. So there are very strict resolutions that a court can give you, that a judge or a magistrate can, or even an arbitrator can give you in a dispute. So there's a very limited amount of room for them to find resolutions that are outside of the box. And that's where mediation is so amazing and fantastic, is you can find the most amazing resolution to problems if you can get parties to actually start properly participating in the mediation process and the purpose of the mediation process, which is ultimately to try and find a solution which the parties can both live with without going to litigation or arbitration. And that's quite a fun part. And I think as mediators, that is something that we find very exhilarating, is trying to steer the parties to a solution which they can both live with. That doesn't necessarily sound in money or provision of services, or it just can be outside the box. So there's another role of mediation. Then what's becoming more and more important in big commercial relationships, from construction to mining to private equity, is that parties actually need to preserve the relationships with one another. There is an actual need for preservation of relationships. And a bit later on, Patrick and I are going to deal with some practical examples of where we've dealt with it. But there is becoming, especially in the commercial space where it hasn't been before, there is becoming a need for the parties to try and find resolutions to matters because they actually can't afford to fall out. Example in a construction dispute, and I know mediation is gaining a lot of traction, I'm sure Stephen can confirm this, it's gaining a lot of traction in other parts of Africa, because what happens is there is a dispute resolution mechanism of mediation built into a construction contract, and as soon as an issue arises, that has to be dealt with within a number of days. That is what is defined in terms of the contract. And the reason for this is quite obvious, because you don't want the entire project to start coming to a halt because now there's a dispute between the contracting parties. So yeah, that is again why mediation is going to start, I think, gaining more traction and going to become more important. Its importance can clearly be seen in the evolution of how things have gone in the last couple of years. There is now a Singaporean convention which countries can sign up to, where mediation settlements can actually be made orders of court internationally. It's commercial mediation settlements, so it is quite limited to trade disputes and commercial disputes. But again, the international community is recognizing that mediation is becoming increasingly important. Clients are also starting to permeate interest in finding alternative dispute resolution mechanisms that are not necessarily arbitration or litigation. You'll find that arbitration clauses will be in almost every single contract that you find, but you are now finding contracts that either deal with mediation or something that's even a bit more airy-fairy, and that's facilitation. So, for example, some of the contracts will say when a dispute arises, management will refer it up to the CEOs, and the CEOs will see if they can find some sort of resolution. Again, it's recognizing that the parties have to find a resolution either quickly or to preserve a relationship. So for me, that's why I think it's becoming increasingly exciting to be in this space, and why people need to understand the purpose of mediation. And a lot of lawyers, I think, have this perception that mediation is going to start cannibalizing their work and their workspace. But it is like anything that happens, and change that happens. You know, AI is coming into space now, and we have to evolve with the space. And I think it is very important to emphasize that a lawyer's role in mediation is very, very important. So there are a myriad of different ways to look at it and to emphasize the importance. The one is to recognize that we need to take some of the responsibility off the court if we can. The second is, if you can find a solution for your client that is quite quick and orthogonal, it's actually in your client's best interest. And in recognizing that, your client is going to start trusting you more, because you're providing them with solutions that are out of the box in terms of recommending mediation. And it shows your client that you're not just in it to go for the long haul litigation or arbitration. And the more you start gaining your client's trust, the more work you're going to start getting from your client. And I can almost guarantee you there's going to be one or two matters that come across your desk that are actually not capable of mediation. So in the long run, it's creating trust with your client. And then in the mediation process, we always find it very useful to have a lawyer in the room, because clients then, A, buy into the process and are trusting of the process, but B, the lawyers can actually guide clients in trying to find a solution that's out of the box. And when they find that solution, then the lawyers can help build the settlement agreement that is behind that solution. And so then you're part of the settlement process and part of the settlement agreement. You can have the settlement agreement if you want made an order of court and all of those sorts of things. But I'm sure Patrick will speak into this a bit more. But it is, I think clients are going to start appreciating it a bit more if their attorneys are knowledgeable about what mediation actually is, and the fact that it can either fast track the litigation process or make it a little bit cheaper, or it can find a solution for them quite quickly up front as soon as the dispute arises. So I think that's my spiel, and that's I hope it comes across as to why mediation is a very, very good mechanism to start considering. And I always finish off with this line: is there's absolutely no downside. It's a completely non-binding process. It's completely confidential. Whatever happens in that process is subject to non-disclosure clauses. The only thing in that process that is binding is if you actually find a solution and you have a settlement agreement. So I always say to clients, there just really is no downside to considering mediation. And then obviously coming out with a solution that may be better than what you get in court in the end.
Thanks. Thank you, Belinda. That's certainly quite informative. I think before we go to the Q&A session, we have a surprise guest for everyone. We have Judge Pile joining us, so we're quite privileged and honored to have Judge Pile joining us. If I can just give you a shortened version of her CV. Judge Pile worked as an attorney in the 1980s. She was noted for her human rights law, including representing several apartheid activists, including Sandile Tusi, Frank Chikani, and Tera Lekota during the Delmas treason trial. Judge Pile obtained her BProc from UNISA in 1982 and her LLM from the University of KZN in 1993. She also has an LLD, which she obtained in 2020. Judge Pile was appointed as a judge of the lower court in 2000 and as a judge of the KwaZulu-Natal division of the High Court in 2010. She also acted in the Constitutional Court in 2021. So we're quite privileged to have Judge Pile joining us. I think before maybe we go to the Q&A session, Belinda, maybe if Judge Pile has anything to add on your presentation, if we can over.
Absolutely, I welcome it.
Thanks, Belinda.
Judge Pile, are you able to hear us? I think she might be having some small. I think she's having some small technical problems. I'll deal with that in the background.
That's fine.
Yeah, Marta just proposed instead that one question I did want to ask Belinda was more to do with how mediation will work, where you've got parties who are properly at loggerheads with each other. How does it work in the sense that there's perhaps a broken down commercial relationship, maybe even some distrust between the parties? How do we get those parties to agree to mediation?
To be fair, Stephen, that's probably every party that's considering a dispute, is they come to you and they're actually just, the reason that they're coming to lawyers to issue summons or to defend summons is because they've reached a point where they actually can't find a solution on their own. So that's almost every dispute that we're dealing with. But mediators are trained to, actually the first thing that you need to do is you need to literally, to put it in layman's terms, to calm the room down and to just get the parties speaking to the mediator. So what you generally do is you try and deal with the combativeness up front, get each party to tell their side of the story. Then you take them into a room separately, and Patrick will speak more into the psychology of this. He's burdened with that task, but there is some psychology in just calming the relationship, calming the room down, having a discussion, getting to know. I mean, one of the mechanisms I use is if it is two big corporations and it's generally not the CEO, but whichever manager is coming to actually represent, is find out a little bit about that manager in terms of their, their working history and stuff, and to start up a conversation that's completely neutral and outside of the dispute, and then slowly bring the conversation as to why they actually started the relationship with the other party in the first place. And generally that brings almost positive news. They entered into the contractual relationship because they were the best in the business and stuff like that. So almost reminding them of why they entered into that contractual relationship in the first place. And that calms things down and allows, as soon as you calm the anger down, it allows people to start thinking a little bit outside the box. So that's one of the few mechanisms that you can use. And again, I'm going to leave the remainder of the question up to Patrick to deal with, because he's going to have a very interesting discussion on the psychology around it. But it requires a little bit of psychology, which is completely against our nature as litigators. And mediation is fun, but you do have to think a lot differently when you're going from the litigation space into the mediation space, both as the lawyer that's helping the client, but also very much so as the mediator.
Thanks, Belinda. I'm looking at the Q&A. I don't see any questions yet, but just a couple of things I think from my side, when the colleagues probably are typing their questions. Maybe costs. I mean, that's one thing I think from an attorney's perspective, can you maybe talk to us about that? And also, what sort of, when you are appointing or selecting a mediator, what is it that you look for? I think from an attorney's perspective, that's something that one needs to understand so that you can then sort of educate your client just on those two issues. Thanks.
Sure. Yeah, I mean, in terms of the costs, again, it's a no-brainer. I should have probably touched on it a bit earlier, is, even there are some mediators that most mediators will charge a very reduced rate in order to, but there are some senior counsel mediators that will still charge their full rate, but because they're so good, people are willing to pay them the 60,000 Rand, because if they manage to resolve the matter in a day or 2 days, it's 120,000 Rand split between the parties, considering the millions of rands and hours and hours and hours of time clients is going to be sitting either in consultation, preparing for matters. At the absolute, I don't care what matter it is, there's such an emotionally traumatic element of litigation, whether it's commercial, family, construction, it can be such a toxic environment, and it is a very emotionally draining. So sometimes it's a hard sell because the costs seem a bit high, but they shouldn't generally be high. So you can get a lot of amazing experienced mediators out there for less than 30,000 Rand, and they're very, very experienced. As I said, there are the outliers like senior counsel that will charge their full day rate, but it is still, if it works, it's still so much more cost effective than a full-blown arbitration or piece of litigation. And with litigation, it's just going to take you so long, especially if it's an action.
And what do you look for when appointing one?
So yeah, that's also a very interesting question. So most very experienced mediators can do almost every piece of mediation, because it's the psychology around it, and it's understanding the psychology around it, and then the facts around it you're going to get out of the parties anyway. And then that's why you've also got the lawyers there, because if you come to some sort of resolution, the lawyers can bandy out what the actual legal ramifications of that are and how they're going to structure it so that it is legal. So I know some mediators that are dentists, that are other medical practitioners, and they're very, very good mediators. But that said, there are, like arbitrators, there are some mediators that are obviously a bit more astute to the issues that the parties are undergoing. So you will have mediators that are very good at construction disputes, other mediators that are very good at family law disputes. And the only reason that I would never touch on family law disputes as a mediator is just because I find it intensely emotionally draining. So there are a lot of different mediators out there that all have different experience, and there are places that you can look to find us. There's many websites with, and many mediators are affiliated with a lot of different organizations. For example, I'm with Mediation in Motion, and you can actually go into the websites and you can find out, and also you can speak to your attorneys, and as attorneys, what you can do is, if you know a mediator, that you can't necessarily brief because you've got a relationship with them, they know the mediation space and they know who's really, really good at it. So there are a lot of mediators out there, and there are a lot of very good mediators out there, and there are ways to find out who would be the most appropriate.
Thanks, Belinda. I see we've got 2 questions in the Q&A. The first question is from Michelle. She wants to know, how are newly accredited mediators able to get exposure so that they may be able to enter the market and start driving the message of mediation as a form of ADR?
It is a very good question, and I know I haven't done it myself, but I know what a lot of people that are starting in the mediation space, what they do is they make sure they get onto the magistrate's mediation role, and then it's almost a secular thing. So whoever's next on the roll will get the next mediation. Another thing that mediation in motion does sometimes, and you have to convince them, is what they do is they allow you to actually sit in almost as a silent mediator. So you just sit in the background and you kind of get the experience and the, just the feel of it. Mediation in motion also, and I'm just speaking to mediation in motion because that's my experience and that's my training. There are a lot of other really good accreditations out there, but what mediation in motion does in their training is they do a lot of practical training, and you can become a member on their website, and then other mediators actually recommend you going through that process. So it's like litigating. It's just getting that first mat and just start gaining traction on that and just getting your CV up and going.
Thanks, Belinda. I see Judge Pila has joined us, but maybe before we hand over to her, there's one more question in the comment section. It says, with the high divorce rates, why is mediation not helping people to avoid divorcing or even divorce as an option? But then divorce should not be toxic given the interests of the children involved. Are you able to deal with that? I think that touches on to the issue of family law issues that you mentioned earlier.
Yes, so I mean, I think by the time parties decide that they're going to go to divorce, they're going to go through a divorce. I think by then there's a fait accompli. So what a mediator's job is, and it's not to reconcile the parties. They're not a counselor. There's a reason why there's counselors out there to try and reconcile the parties. But what the mediator's jobs are is to try and make the process as amicable as possible, and for the children as the least traumatic as possible. And very good mediators are just able to, as I said in the beginning, you kind of need to neutralize the anger of the parties going in and remind them that, they once loved one another, and try and bring them into that space, not just by saying you once loved one another, just trying to remind them of what they appreciated about one another at the beginning of the marriage before it started going wrong, and remind them that there's children involved and it's a children's interest. So it's very much, again, Patrick can speak into the psychology of it, but it's very much just bringing the parties out of a space of complete anger where they just want to pummel one another with absolutely everything, to a space where they can actually find a way to find a resolution to this without damaging their relationship further and without damaging their children's relationships with them. So as I said, the one reason I don't do divorces is because I can't bring myself to the emotional impact that I'm possibly having on these people if, for example, the mediation doesn't work out. Whereas, with commercial mediation, there's a little bit more, there's less emotion involved in terms of, you're dealing with corporate entities rather than people's lives that are at stake.
Thanks, Belinda. I think before we hand over to Patrick for his portion of the presentation, maybe we can give the judge an opportunity. And Patrick, if he has maybe something to add onto your presentation. Thank you.
Thank you, and I'm sorry for all the disruption that I have caused. Yeah, no, I'm great crashing your program, and I have somebody waiting for me, so I'm going to be quite brief. And you see, sorry, I'm really sorry. Sorry, everything's fine, Eunice. Yeah, okay. I think there's two impediments. Well, mainly one that I saw, and in family law, and that is that the practitioners, because the most amount of money a practitioner makes is based on the time spent in court, not in the pleadings, not in anything else, and it's time spent in court. So I found practitioners to be the greatest impediment, especially in family matters. The second thing is that when in a family matter, they come to court and it's a Rule 43 where they're claiming maintenance and access and all sorts of other things. But they've already decided that they're getting divorced. And so why don't you just collapse both processes into one? And it just, you know, practitioners will stand in the way and you can't get past that. But I also found that a single text facilitation, you know, you list all the things and if the judge puts out or the mediator puts out, here's the possibilities on maintenance and access and so on. So you focus the minds on the outcome, and people are focused on what you have on your text. And that gets to the end sooner rather than later. And but I've also found that once we like about to settle and sign, the practitioners will come and say, no, we have to think about this. And a couple of times they've come back. But I was hoping at the end of it to look at mediation pre-democracy and into democracy. And I just want to make one single point, and that is that pre-democracy in the 80s, the culture of conciliation, the culture of dialogue was cultivated by the mediators, cultivated by appropriate dispute resolution practitioners, and laid the basis for political transition. And I'm wondering why we can't recultivate that in this time of a government of national unity, in a time when democracy is internationally in a recession. It's generally acknowledged that that is the case, but also 30 years after the Cold War, I'm hoping to, and when I put my optimistic hat on, I'd like to think that there is a gap or some shifts, not necessarily tectonic, but certainly some shifts in politics that creates the opportunities to recultivate it. And I'm saying this optimistically because the reality is that if one is not optimistic, then we've hit the wall. We've hit the wall and there's no options. And what do you do next? You can't go on in this fashion. You can't litigate like 28 cases pre-election and hope to stop the elections. And let me boast a bit here. The Electoral Commission won all of those cases, and we're waiting 3 judgments. We didn't win one by the DA, which wants us to run elections in foreign countries where businessmen and other non-honorary consulates are going to be responsible for what is essentially a state-sponsored duty. That's an aside, but that's one that's outstanding, and a few others that 2 or 3 others. But we can't have this non-dialogical state of being. And is this not an opportunity is the question that I have to answer for myself, and I'm hoping that the panelists here and the participants would throw me some bones to chew on. Thank you. Thank you for this opportunity.
Judge, thank you very much for joining us. We very much appreciate your time and taking time out to come and discuss these issues with us. We do feel honored by your presence. Thank you. I'm going to hand over to Mr. Deale, who will take us through a few more topics on in depth and give us a bit more information. Over to you, Patrick.
Thank you very much, Stephen and Vincent. Thank you for the introduction, and nice to meet you face to face, Belinda. And great to have you join us as well, Judge Belinda. I'm going to touch on a few things, and I think just for openers, I just want to share with you my sort of mindset of how we deal with conflict and disputes, conflict management on the one hand, and disputes, when they become real disputes on the other. And the way in which I think of it is like a drama. There's like a play going on. There's a plot going on, and they're actors, and they are jostling for position in trying to participate in whatever this drama is. And they all have different motivations, and they have different end goals of what they want to reach or where they want to go. And they use strategies and tactics to be able to advance whatever those motivations are, whatever those intended outcomes are. And part of the job, or a big part actually, of the job of conflict management, in other words, the pre-conflict stage, you know, when it's kind of building up slightly and it could end up nasty into open disputes, is to figure out actually what's going on. Why are people behaving like this? It's human behavior that causes the disputes. It's human behavior and human needs that causes the conflict in the first place. It's got to do with scarce resources. It's got to do with egos, and all sorts, a whole range of human issues. And one of the things I try and do in a mediation or in any conflict situation, it might be a facilitation, a multi-party facilitation, or a one-on-one between two people, partners in a business who have had a fallout, or on a board of directors or whatever, is to figure out what's the main plot going on here. Really, what is it that really they need? And to figure out, you know, especially when there are lots of people involved and they've got a team of people, who is the prime mover, who's the talker, and who's the actual mover behind it? And so that's just one dimension of the people dynamics of how mediations operate and the climate in which they operate. And the underlying psychology of conflict management, I think there's one single thing that drives it when you're in conflict and when you're in dispute, is the driving force is fear. You're fearful about the situation that you are in because you don't know where it's going to go to. You don't know, you can't see what the final outcome is. And so the uncertainty of it, of an unresolved conflict, an unresolved dispute, is what keeps people's brains occupied at night. They think about it incessantly. They look for support from fellow colleagues at work or fellow colleagues in a business to confirm to support them in some sort of emotional way. I'm just talking really about the emotional side of participants in any conflict, in any dispute, which is an essential ingredient of how to manage conflict effectively. Because in contrast to court litigation and using the law as the instrument upon which to decide things, emotions basically don't come into it. But emotions and the human condition come into dispute resolution and conflict management hugely. And so what are the fears? The fears are of the outcome. You don't know what the outcome is going to be. You don't know, what damage is going to be done, and that damage could be financial damage. It could be a whole range of other things, and also threats. There's an underlying threat that is involved, which is obviously attached to the fear, and all of these emotions play out in a court situation, not in front of the judge, not in front of the litigants with all of the piles of pleadings and cross pleadings and so on, but in the minds of the litigants. And it offers a zone within which mediation can really occupy a space to deal with both the emotional, behavioral, human dimensions of conflict management and dispute resolution, but also the tough commercial business issues as well, and obviously in relation to legal issues as well, about what your prospects may be if you had to go to court. And so another big difference in the psychology of things is that people really tell you the tip of the iceberg about what the problem is. They tend to talk about what we call their positions. I want this. I'm not going to necessarily tell you why. I want it because I want it and I deserve it. And they get locked into what we call positional negotiations, positional bargaining, and you end up going into a cycle of he said that, and action, reaction, and so on. And as a consequence of that, your range of opportunities to try and find some other solution to it is so limited, because the circles of action and reaction just rotate, infinitely into a kind of a small dot in the middle, if you like. And the parties get angry, they get frustrated, and it starts manifesting in all sorts of behavior, shouting and anger and fist banging and taking to the streets and God knows what else. And all of that is what a court is faced with in litigation. I'm going to get my lawyer. I'm going to get the tough lawyer. You never talk to about and I say, look, I'm going to go, give me an average lawyer. No, people want a bulldog. They want to go into court and they want to hammer the guy and they want to just, give it stick. Don't give me a mediocre lawyer. Give me a really good lawyer. It's the best lawyer to go on. I mean, that's the kind of language, So it's like calling your big brother into a schoolyard scrap in many ways, to kind of strengthen your position and somehow influence the other lawyers and so on that you're going to win. But meantime, you've got a judge sitting up there observing all of this drama going on. And I'm sure Judge Pillay will have seen this a hell of a lot of in her vast experience of these things. And what the lawyers in this kind of mind frame do, they rise to it and they act tough. And even to extent where they don't even talk to the opposing party and so on, and they write long and longer letters and more furious letters to each other. They get longer and longer, reserving rights and threatening this and that. And so it just, the climate, is just not very happy climate, quite frankly. And disputes quickly go into that kind of zone. Immediately, a lawyer is called upon, a letter of demand is sent, a summons is gone. You start going into that zone of, I'm going to win. And that's the thing about it. I'm going to win and you're going to lose. There's a winner out here. This is Roman charioteering. You slug it out, and you go around and around until someone wins and the last man standing. And you just hope it's going to be you, not the other guy. So it's a binary outcome that you're facing with. And so what the natural instinct then in this situation, when faced with conflict, is fight or flight. And those are generally the human conditions on this thing. I'm either going to stand up, I'm going to have a barroom brawl, I'm going to fight it out, or I'm just going to gap it out the back door and I don't want anything about this thing. I'm not going to fight the thing. And it's hardly anything in between. It's hardly anything in between. So, well, what is why are you behaving like this? What is the problem from your point of view? There's no listening that goes on, and so on. And so litigation is very limited in its range of possibilities. And judges have a limited range of options to deal with disputes. And they have to decide it in terms of the law. They are bound by the four corners of the law. And the law cannot prescribe cannot anticipate every factual situation that is presented before a judge, before a court. And so to the best of its ability, it is a kind of broad scope of things that you can do, that you can't do. You can do this with a contract, but no further. You cross the line, if in a building construction site, if you do this and that. And so, and that's all the law can do, and all judges can do is saying, apply this section and that section, and you're either right or wrong, and it could go either way, depending on what the facts are and how the evidence stacks up, and so on. And just insofar as the parties are concerned, they put themselves at the mercy of the law. They put themselves at the mercy of the judge. They have no control over the final outcome. They have control over the manner in which they have their cases presented. You know, they hopefully they've got the merits on their sides insofar as facts are concerned, and whether the law supports them. But ultimately, they don't have ultimate control over, because someone else is going to decide their fate. And it's one of the big values of mediation, is that in mediation, the parties retain control over what the outcome is. And it's a great value of it.
If I may intervene for a moment, I'm very sorry to interrupt. I see Judge Pillay has raised her hand. I think she may want to comment.
Happy, yeah.
I didn't mean to interrupt Patrick, but
No,
I
please,
thought I should just signal that I have limited time, but I also need to, I'd like to respond if I may. I agree with you, Patrick. This book is still my Bible, Mark Anstey's Negotiating Conflict, and I used it in my my thesis. But I think maybe a line that might be, that I find quite convincing as to why one shouldn't litigate with the people I work with, and that is that you can have a panel of 5 judges, and you can have 10 points and 20 rules to apply. And you can have as many permutations of the 10 points to the 20 rules as there are judges. So there's the idea of right and wrong answers is something of the past. There's I mean, the Barnard case, for instance, is like the facts were not in dispute, but yet you had as many judgments as there were judges in the case. And there was only one person who realized that this was a case where social reform was at issue. And that was a judge in the court of first instance. And when I looked at his history in the thesis that I included a study of Barnard, it was Paul Pretorius. He's the only judge who mentioned mediation to the parties, and they didn't take it. But you know, dispute resolution and conflict management kicks in when there isn't adequate common purpose and reciprocity in society. And people, you know, the worst feeling you can have, as Patrick, you point out, is those sleepless nights when it gnaws you and you don't know which way to turn, and there's no therapist who's going to find you an answer. But to know that you control the outcome is a far better situation. And so for me, I think at this point, when I talk about common purpose, I think that's what I mean, that we have I'm hoping to say, I'm hoping to find that there is a sufficient level of finding common purpose at this point in our evolution as a democracy. And if we can't find that common purpose, is there a basis for quid pro quo reciprocity? And then what's left in the balance that we can't agree on? That is the only thing that should go to litigation, and on a very clear mandate to the judges, that we want you to decide on this limited basis. But we don't process disputes to that point of refinement. And that's where mediation, maybe we shouldn't tell people don't go to court. Maybe we should tell people go to court, but let's do this first. Let's refine the issues. Let's find the common purpose. And we give the court the common purpose to work with. Then we give the court to say, here's the part that we can do a trade-off. And here's the other part we can't agree on. And this is what we want you, Madam Justice, to resolve. We have to look at other ways of hitting this thing. we can have all the rules of compulsory mediation, and they just tick the boxes. There was that rule that was introduced and didn't really work. I mean, and we've got to address the needs of practitioners. It's the only way they make money. So where are they going to make money? We've got to show them that they're going to make money through mediation and in some ways and arbitration. I'm sorry, I don't mean to go on, but thank you for that. If I leave, it's not because I want to be rude, but my guest is getting impatient. My other appointment.
Judge, thank you very much for coming. Appreciate it. Nice to see you.
Thank you very much, Judge.
Thank you.
Thank you, Judge.
Yeah, I think what Judge Pillay has mentioned is a very important sort of part of the process around dispute resolution and conflict management. That is common purpose. If you've got two circles and the two circles never meet, they're never going to meet. And litigation decides this circle or that circle. It doesn't look at trying to say, well, where's the overlap between these two circles in my worldview, in this particular dispute and your particular dispute. And we know that in litigation, the pre-trial conference process should actually narrow things down properly to things which are in dispute and things which are common cause. In other words, what are we going to fight about? What are we not going to fight about? But I don't do I don't do any high court litigation, but I do mediations about high court litigation, and I don't see any, useful value in a lot of these pre-trial minutes that are presented in terms of the possibilities for the common ground versus the things in dispute. And I don't know whether others can comment on that. But if it were possible to do that, then during a course of a pre-trial conference, where the whole purpose is to try and settle it, actually, and if you can't settle it, to try and minimize the job of the court, to relieve them of having to deal with all your troubles. So the process of reaching common cause and identifying and minimizing the disputes and maximizing the common cause could actually be in itself a zone for mediation between parties in a pre-litigation stage to try and help them identify what's possible and what's not possible. And hopefully from there, then you can start focusing on what issues are in dispute and using different mechanisms of mediation that can possibly solve it. And this is just another topic. While we're talking about it, I could mention the varieties or variations of mediation which may be applied. So if you think of mediation is what it means, trying to find a medium between the two, it's not necessarily the 50-50 kind of split, but it is something where each party says, okay, it's a give and take. I'm prepared to give that if you can get that. And there are these trade-offs as the end point of an informed negotiation. And I stress an informed negotiation. But if you can't agree on everything, there are issues in dispute. There are different modes of mediation that you can use. The first one, we're actually this stage, is a fact-finding thing. What are the facts? What are your version of the facts? What is your evidence of the fact? And get someone to determine these are the facts, because if there are disputes of fact, it's difficult to mediate where are disputes of fact. And that's mostly a court comes in to deal with disputes of fact and to decide them on the probabilities and so on. But if you can get a mediator to identify common issues and to do a fact-finding on disputes of fact and present them to say, that's what, those are the facts as I read them, and present them to the parties, and then you go into a med-arb, which is a combination of mediation and arbitration, and you say, look, you are at 7 and you are on 6 or 5. Let me try and see if I can get you closer. Are you prepared to come closer together? And you can kind of get the mediator in a mediation mode to get them closer. But what you've agreed in advance of doing this is if the mediator can't get you to shake hands and agree on everything, that you can get the mediator to take his mediation hat off and put an arbitration hat on, and then to arbitrate the difference between the two, between the 3 and the 7 or whatever it is. And in that way, the parties are motivated now to take control, to get as close together as possible before someone else comes and decides for them. And that is the need of a mechanism. And it can go further than that, is that once it's been to an arbitration, what you can do, you can go back into an arb med, where you can say to the arbitrator, make a decision, and don't tell us what it is. But you would have heard our stories, our versions, you would have heard our arguments. Put it in an envelope, but don't tell us what it is, and keep it as a secret. And we'll go back to mediation. So after the process of a kind of semi-litigation experience on a range of disputed facts, which the arbitrator has listened to and made a decision about it, takes his arbitrator's hat off and goes back to being a mediator. It says, all right, now are you prepared to come closer? And they come and they try and mediate closer. The arbitrator hasn't told them what the result is, to try and get them closer and closer. And if they do it, that's great. The envelope gets thrown up and they don't hear what the arbitrator ever said. But if they can't agree, then they say, Mr. Arbitrator, we're in dispute, we can't do it, open the envelope. And the arbitrator then opens the envelope and voila, that's the result, So you lead them to the edge, and then you bring them back and you lead them to edge, and you're forcing them in a way to find common sense and to find common grounds. And it's, they use this, and there's another variation of that, what they say, well, look, we can't resolve this thing. This was our last offer. Our last offer was 4. And your last offer was 8 or 6. Mr. Arbitrator, we can't decide. We ask you to please arbitrate between 4 and 6, based on the facts, based on the law, and all the evidence. And you decide whether it's 4 or 6. In other words, what's called last offer arbitration. Now you're playing roulette now. And you can, when you get closer and closer to there, when they put their arguments forward, you can say, well, look, you can draw back for the arbitrators. They hang on a second, and they get the parties to go and quickly have a conversation. Say, really, do we want to play a roulette, or should we just find some common ground here? And so these mechanisms, are available in mediation and can be explored to expose parties to the reality of managing disputes in an inventive and in a creative way that they haven't thought about, which litigation most certainly cannot do for them. So those are variations in mediation, or generally of facilitation, that can be very useful. And perhaps what I can do is just talk about risk management and the approaches to mediation and other forms of dispute resolution. I've put together a thing called a risk assessment matrix, which gives us sort of like in a picture form, if you like, an idea of what processes are involved and what are the factors that determine whether people go to litigation or whether they go to arbitration, and what are the risks. All of this stuff has got to do with risk management ultimately. And Steve, if you've got that picture there, could you put it up on the screen and I'll just show it to you? And I'll just share it with everyone. This thing, you know, it's a recent innovation. I've had a first version of it I did a labor dispute version of this thing, but I've been talking to my colleagues at Conflict Dynamics around this, and I'm working with them, and they've come up with some ideas about it. John Brand and Felicity Stedman, they've just happened to sort of fine-tune some of this. So it's in work in progress. So Steve, have you got it there that you could just pop it up?
I'm getting it onto the screen as we speak. I think it may just be taking a moment or two. One moment.
Okay.
I'll be with you in just a second, Patrick. My apologies.
No, that's fine. And it's something, you know, that people who, you know, young lawyers, or don't have to be young lawyer, but you can be a lawyer who practices, you know, in the dispute resolution zone, this area of law we're talking about, as a way to, you know, discuss with your client right at the beginning of the consultations, when you're first being briefed on a particular dispute, on what the options are for your client to get them the best result. At the end of the day, all they want is to get the best result, whatever that may be, whether it's the fair result, it's the economic one, or whatever. They want to get the best result, basically for the least money and for the least stress and in the least time. That's really what a party in a dispute wants from a lawyer. And if a lawyer can provide a service that's going to provide that effectively, I think, like in dispute resolution, having options available to choose from and to move into one to the other, and just to, you know, be a bit flexible the way you do things, it could offer a great degree of possibilities for alternative dispute resolution, which is the subject matter we're generally talking about, ADR. Unfortunately, as I say, it's normally a binary choice, this party between that party, this applicant or this respondent versus that one, and this plaintiff versus that defendant, and you know, win or lose. And I just think that there's so many other possibilities that are feasible here. So if it's not coming up, Steve, don't worry about it. Is it coming? Thanks for that. Is it possible just to expand? It looks a bit busy, but I'll try to explain it to you. Okay, can it get a bit bigger? Okay, now I think we should be able to read that. Look, I won't go through all of the detail of this thing, but just to give you an idea, it's a risk assessment thing, a measure, and up in the top left-hand corner, you'll see a little box there at the level of risk. The pale green there is low risk, medium is orange, and high is red. And what I've just tried to do here from a kind of a visual point of view is just give an idea of about a civil dispute, and where it could possibly go and what happens to it during the course of a resolution. And down the left-hand side, you'll see there's a process there. There's a heading to process, and there's description. And the elements there are things to take into consideration when you're going to go into litigation. Management time, you're going down the list, degree of stress, damage to reputation, duration of the process. Is it going to take 1 year, 2 years, or 3 years? The time taken to get there, because, you know, you get the pre-process and then there's the actual process of the trial, the legal and related costs. And a big thing is the uncertainty of the outcome. And then the factors is that whether or not the outcome is determined by the parties or by someone else, and whether the outcome is enforceable. Often you get into a huge litigation, pay a hang of a lot of money, and then the thing's not enforceable because the other party doesn't have the money, or there's some other problem or other. And then there's also the issue of confidentiality, which is related to reputation. And if you look along the top horizontal, there are various categories there. There's informal resolution option, There's the pre-litigation stage, there's the pre-trial pleadings, and then there's the actual trial processes, assuming it goes all the way to a trial. And what happens along the way? Along the way in the informal resolution, you have some negotiation, and perhaps you could have some mediation at that stage. At the pre-litigation stages, that's when negotiations are broken down, mediation hasn't worked, and then the demand is fired off. We demand this by such and such a date, you pay us this big chunk of money, and so on. But even at that stage, mediation is possible. The pre-trial, and then you're ramping it up, you're on to the summons and you filed a defense. And then in the trial proceedings, there's the trial itself and the hearings in court. Even then, during a trial, mediation is possible, but then you might have an appeal afterwards. And so, all in all, what this matrix says is that where the red zones are the high-risk things, in the legal demand, in the summons, in the trial, and in the appeal. And in the orange zones, after the processes have failed down, sort of unfolded, you've got zones where are medium risk, where mediation offers opportunities, and obviously in the green shades where there are greater opportunities. As I said, there's a lot more information here. But just on this matrix of an ordinary trial, just assuming that there's one attorney and one advocate, and the cost is, say, 30,000 Rand each per day, for a 2-day trial, from beginning to end, it's a minimum of 420,000 Rand just to start with. And so that's what all this tries to do. And at any stage during this process, there could be a kind of a cold shower for parties to think maybe there's a different way of doing this. So it's just a visual demonstration of how to look at mediation and an ongoing possibility for resolving as it unfolds. If parties can't agree at any time, and hopefully they can agree at some time. So that's Steve, thanks for that. I mean, we can bring that down. So I think that's just, perhaps I can hold it for there. I can talk about some other issues if needs be, just to open it up. And obviously, Belinda, if you'd like to add to anything I've said, I welcome, and any questions.
Thank you very much, Patrick. I actually have a very brief question from my side, maybe to kick everybody off. And I do invite everybody, please use the Q&A function within Zoom to give us your questions now. We will answer them live for you. Our panelists will answer them live for you as well. You were talking earlier about the psychology of mediation, and the idea that it really has reached a point where the parties are at loggerheads. They're now threatening to go to litigation, or they are in litigation. How do you, from a psychological perspective, bring those parties back from the brink? You've got a lawyer whose duty is to say to them, well, this is what your position is. This is what your legal position is. This is the case law, which says that you're likely to be successful. Of course, there's no guarantee. I mean, the position may even be trite. The case law may even be trite on the topic. How in those circumstances can you say to the parties, look, mediation might still be a good idea?
Yeah. Look, I think thanks for that, Steve. It's the uncertainty at the end of this thing, because you're going to win or lose in litigation. And all sorts of things can go wrong along the way, and you just don't have control over the courts and what judge you're going to get and whatever. And how a witness is going to perform. I mean, there's so many variables in the whole thing. And so, when you're being briefed of that, you want to, if a lawyer can say to a party, look, you've got very good prospects. I think we could win. I think we could win. Not I know we can win. I think we can win. And for so long as there's a little margin, a little givey about the little thinky thing, there's a doubt. And the moment there's a doubt, it opens the door for kind of having a little bit of a look at this thing. And that's when you go to the other parties, lawyers, and say, listen, chaps, let's have a little off the record here. Let's have a conversation about it. And perhaps we can go to get a facilitator or a mediator. And I think that's responsible lawyering, quite frankly, to do that, to at least explore it. And even if the client is, absolutely adamant about it and say, look, let's at least try it. At least you've tried to push them in that area. And at the end of it, you can say, well, look, we did talk about that, and you decided to go into the bull ring without having a look about what else is available. That was a choice. And so, obviously the client can make their own choice, but you've got to give them an opportunity to make the best informed choice for the best possible outcome. And that is opening up the range of possibilities and informing them about this risk analysis that I've talked about. The risk analysis that I've been talking about is exactly trying to answer that question, to show them that even though we reckon we're going to handle this, as you say, it could be trite, hands down, something can go squiff in the whole thing somewhere, and then where you are you? So, and also mediation, part of being a good quality mediation in the first place is to demonstrate good people skills. And people will arrive there hostile. They will provide there with gladiators and etc. Although they, philosophically ought to have got their minds around the possibility of trying to settle in a mediation, the mediator's role is to create a conducive environment, to change the climate, to change the environment. It's just the mere way that you speak to them, to the language of mediation, the language of conciliation, makes a hell of a difference. It just calms it down. It brings out all of the legalese and all of the Latin and all of the threatening and all of that kind of stuff. And it brings that to the human common discussions. There's a thing called common sense that still actually prevails out there somewhere. And perhaps we can use it much more and help the parties to look at it and to think differently on the basis that it's so-called it is without prejudice. They can go off the record and they can go back on the record if they don't get anywhere. So it's creating the right climate and the mindset, but getting the lawyers to tell them or to inform them about the options and the range of things that are possible. And I don't know whether, Belinda, you do that as well with your clients when they're faced with a dispute and possible litigation?
Yeah, I mean, we have started now doing a proper risk analysis, not as detailed as yours, but it is something that we go into our clients with. I've always had the philosophy that, a bad settlement is better than a good case, because as you say, there are absolutely no certainties. There's no way any of us can guarantee to our client that they're going to have the outcome that they want. And also bear in mind, we can have a bunch of documents which we think our client has got a slam dunk case. The other side might have equally a set of documents that we haven't yet seen yet because there's no discovery and our client hasn't bothered to give it to us. And you're assuring your client that they've got an amazing case, and then one email comes out. So as Patrick says, there's so many variables and there's just no downside to considering mediation. And your client will absolutely be so grateful for it.
Yeah. Any other questions? Thanks, Belinda. It's good to hear. Yeah.
I don't see any questions in the Q&A box, but I think just to link my question with what Belinda says. I think we are all sort of pro mediation, but are there any disadvantages? You can think of. I'm now thinking issues of maybe enforceability and the like. Are there any sort of disadvantages that parties need to keep in mind and accepting all the advantages that everybody has spoken about?
Yeah.
Thanks.
I think whether we call it a disadvantage or a risk, which are first cousins, the notions, Vincent, is this notion that when you're in a dispute and you're going to go to court and you're on your way to court and you want to win and you want to just give the other side a good clap, you're in a mindset of not wanting to reveal your cards. You don't want to, you might have an ace up your sleeve. And they might fear that if you go into mediation where it's off the record, yes, but you've got to kind of talk about your interests. What's really, what are your real fears? Those kinds of things. And if you don't want the other side to know what your real fears are, because you're busy putting your tough front on. You don't want to know that you are vulnerable in some sort of way. And I think that parties might, one, fear mediation because they think that going to mediation is some sort of admission that they don't have a good case. It might convey the impression that they've got a weak case, and it shows weakness. We think that's the absolute opposite of that. Because if you say, look, we've got a good case, but I'm happy to talk to you. I mean, that's quite a mature approach to dealing with issues. And the other thing, as I said, they might have some little trick, although this is Hollywood litigation, that you produce, the smoking gun or the witness that is going to spill all and just nail your case completely. And they don't want to tell you until you get into the court and before you reveal it before the judge. And they wanted that kind of thing, that, you'll be giving too much information away about your case strategy and what you are wanting to, how you want to win in court during the mediation. And although it's off the record, once it's heard, it's heard. You can't undo the hearing or undo the knowledge. And I think that is a little bit of I don't know whether it's a negative or a downside, but it is a thing that people can be concerned about. But in the mediation process, a mediator should manage those fears, because the mediator deals with parties not only together but also separately as well. And separately, they can tell things to the mediator which are confidential, so they can cry on the mediator's shoulder and say, "Geez, I'm really worried about this. This can't get out. For goodness sake, don't tell the other side about this. But this is really what my fear is." And that's why I put the tough guy image up, because actually I'm really vulnerable inside. And that's the mediator doesn't go and tell the other side, look, these guys are really worried about this. How about settling? That sort of thing. So it's got to do that mitigates any kind of downside insofar as that point is concerned. I think in a mediation, the mediator treats confidentiality, which is the golden rule, properly and fully. Yeah.
If I can just add to what Patrick says, I think it's understanding the difference between litigation and mediation, in that the mediator is not there unless, as Patrick says, you have a combination of mediation and arbitration. But a pure mediation, the mediator is not there to make a decision. The mediator is not there to judge you. The mediator is there to try and bring the two of you closer together. So sometimes those little nuggets and snippets that you're worried about revealing during it are actually not relevant to the mediation. So I agree with Patrick that it's a very legitimate concern of parties, but parties also need to understand that the purpose is not to nail one another during this mediation or to reveal little tidbits. You have to find the facts, but you also just have to find a way to bring the parties together on sometimes the bare minimum facts, because I don't want to reveal everything to you. But yeah, I agree with Patrick that it's a concern for parties, but an experienced mediator will be able to alleviate those concerns for parties. Yeah.
Just to lastly on that point, the biggest sort of early indicator whether mediation is going to be successful, whether mediator, if you're going to call the mediator successful, but being a good mediator, is to earn the trust of the parties. Literally, in the first 15 minutes of it, you know, of the you know, of the engagement. This is where I think, you know, we not only use legal knowledge and skills, but we use EQ. I think you, as a good mediator, I think you need good EQ, emotional intelligence, apart from a spot of old, you know, ordinary run-of-the-mill intelligence, IQ. But you need to understand the human condition. This is why I was talking at the beginning, how I see these things as a drama. You need to understand, you know, what's happening. You can see signs and see how people are reacting and respond to them in such a way that you are developing trust, that they trust you. And the more that they trust it, it's interesting. Once the thing, you can see the trust building, you can see it building. And the more it builds, the more the eye contact comes, the more the body language comes, the more they can start sharing facts with you and things which, you know, it starts just relaxing. And it's amazing, you know, how effective it can be just to release people, and how relieving it is for people to be able to talk about what really is bugging them in these disputes, you know. Yeah.
Belinda, a question that's come privately to my phone from somebody who's listening in, asking, I think this is actually especially relevant for people who've joined us this evening, people who are young practitioners in the industry, and people who are even just really starting out in the industry as students even. Considering that you've in your words recently qualified as a mediator, and you're part of Mediation in Motion, and I can see you smiling at this. Where do people start? You know, if they want to look at becoming a mediator, Patrick, I'm going to pose the same question to you. But if they want to look at becoming a mediator, in your experience, where should people start?
So I think what you need to do is actually do a mediation course so that you can see the value in it. And I did mine through UCT, who are affiliated with Mediation in Motion. I know Stellenbosch has an accreditation course. I'm not sure about up north, whether those universities do it. I'm sure that they do. There's international courses that you can do to become affiliated with international platforms. That there, you know, it obviously starts becoming a bit more expensive, but it's a way to expose yourself to more and more platforms and make yourself available for these. And I mean, I've done few mediations, not very many, but the way I got into it initially is I actually offered my services for free, you know, and then people are like, well, there's nothing to lose. And then you start building up a reputation but the first thing is to actually get an accreditation. And it's not just so that you have a certificate, it's so that you properly understand what is required of you when you walk into that room. And as Patrick rightfully says, you need to gain trust of people almost instantly. So my very, very first experience with mediation, I had a client who was suing another client. We were advised, the client was advised by a friend to go to mediation, and he did. But what happened is the mediator pitched up late and wasn't all there and didn't actually quite, and we'd given them a statement of facts before so they could just understand what the issues were. And they just came in wholly unprepared. And I can tell you, in that first 5 minutes, they not only lost my client and the lawyers in the room, but they lost the other side too. So it is extremely important to learn the skills, and those skills are, you know, they're valuable, and that is what you learn when you go on a proper mediation course. And I'm sure other institutions do it, but Mediation in Motion does refresher courses, and they're starting to be affiliated with a lot of pro bono institutions that are trying to get traction in mediation, and we initially do pro bono work for them. And unless you go on these refresher courses, you can't put up your hand to be a mediator in these programs and these projects. So there's a lot of ways to do it out there, and I'm sure Patrick's got some nuggets of himself, you know, of his experiences and where to go. But for me personally, it's been Mediation in Motion, and as I say, I do know that there is a course in Stellenbosch. Mediation in Motion is through UCT.
Yeah, I am. Yeah, I mean, it sounds like a bit of a. But my sort of beginnings was way back in an institution called IMSA, which was a non-profit organization, basically in the labor field, dispute resolution. So that's where I learned mediation. And getting into the labor field as a mediator is one way to get in, because there are many more disputes, and mediation is almost bread and butter in the labor territory, because the con of with the conciliation process is a compulsory step in the resolution of all labor disputes. And so it's not even ADR at the moment there. Conciliation is mediation. It's kind of mainstream in the labor field. So that's one way to get in, is to get into labor dispute mediations and resolution. And on the commercial side, I learned commercial mediation through conflict dynamics, which is a very, very solid organization. It's been going well for, I don't know, since 1996, I think. A lot of my colleagues are on it and so on. And I'm actually a coach, an assessor on the mediation training of commercial mediators at Conflict Dynamics. It's a 5-day course. It's extremely intensive, it's really, really, really good, and it is accredited by CEDA, which is the UK equivalent of the CCMA, which is the Centre for Effective Dispute Resolution. And people who qualify as mediators through Conflict Dynamics can also potentially qualify as mediators, be accredited by CEDA in the UK, which gives them an international mediator status, particularly on commercial mediation. And if you're looking at the full package of mediation skills, this is tried and tested, and very intensive. It's a 5-day course, Conflict Dynamics runs them pretty regularly. I think they've trained, I'll have to ask Felicity, but it's 300 or 400, maybe more mediators over this period of 10 or 12 years since the mediation training first started. I was trained in, I think it was 2006, somewhere around there. So where the first course was done, and now we've developed it all the way along, and it's just been fine-tuned. Every year it just gets better and better and stronger and stronger. So that's one thing. That you need to have insight to understand it. And then the third thing is to market yourself. And you market yourself by, going to pair with other mediators, just to sit there and observe, with the permission of the parties, and just experience what it's like and start getting into it. But at the end of the day, like all things, you've got to sell yourself. You've got to get the reputation. You've got to get the ticket, I think, and you've got to sell yourself. So you've got to market yourself as much as possible. Yeah.
Wonderful. Thank you very, very much to our panelists, Patrick Deale and Belinda Scriba. You have been absolute stars. We've learned a huge amount from the both of you tonight. And I'm hoping that our participants have gained valuable insights. I certainly have. And it has piqued my interest in mediation. And I'm certainly going to be looking into it in more detail. And I know Judge Pillar has already left, but in her absence, a vote of thanks. Patrick, I know you assisted us in getting Judge Pillar on board as well, so thank you for that too. And we are going to be hosting future sessions in a bunch of different respects in this thing, to train young people to be able to deal with and get more experience and insight into these valuable concepts. So from my side and from Young AFSA's side, again, to both of you, thank you very, very much for joining us, especially and staying so late as well. And from Young AFSA's side, to all the participants who joined us, we are very, very happy to have you on board with us. If you do have any questions or whatever, please do feel free to get a hold of us on our Contact Us page. And we do hope that you will join us in the future sessions as well. That is all for us from us for this evening. And again, thank you.
It's a pleasure. Thanks for having us.
Thank you. Thanks.
Thank you. Thanks for having us. Good luck.
All the
Nice
best,
to meet
guys.
you.
Bye.
Okay. Bye-bye.
All the best. Thank you again. Good evening.
Bye-bye.